step number 3 is the case conference.
Mhm.
Okay. Now, many people go to the case conference not knowing exactly what to expect. I don't know if you have any videos on the case conference. Maybe that's something to think about. But for our purposes today, we're just talking about the disclosure. And for the case conference, you have to think about your disclosure and the other party's disclosure. Okay, so for your disclosure, you're going to have to provide with your case conference brief a Form 13A financial disclosure certificate. And all that is, this is what it looks like.
Mhm.
And you're not providing any documents with this certificate. You are providing a list of the documents that you've already provided.
Mm.
So, for example, if you provide, you would have had to provide your notices of assessment with your financial statement. So you would put, I don't think I can annotate a little bit. You would put right over here the list. This is like 1, 2, right? 3. You could just do that. And then you would type in the notice of assessment for each year. Notice of assessment do have a date. What I do is I put the date into the file name. So it actually shows up over here.
Mhm.
And then what date did you provide it? Okay, and it's hard to keep track of this stuff. It's a little bit easier nowadays because everything is sent mostly via email after the initial service. So you do want to keep track of when you send stuff to the other side because you want to collate this information to you want to collate this information, and as this form keeps going, and it's basically trying to gather. Personally, I use a different form because I like to have information that is follows very closely to the financial statement. But here we go. See, there's real estate here, savings and investments. I would have a heading over here for vehicles and household goods if that's an issue. Do you see? Because it's not following the financial statement for some interesting reason. So this is a list, and you need to provide it as the case goes along. Okay, so that's the Form 13A that's going to be filed at the time of your case conference brief.
Mhm.
Just the list, not the documents.
Mhm.
Okay. Then you're going to also need to get really ahead of the curve, and really, Heather, this should be a separate video, which you and I can discuss, about figuring out what is lacking from their disclosure. And there is a form. It's called the Form 20 Request for Information, but really the form is not, there's nothing special to the form, which I'll show you in a second. You can do a letter or a list in your case conference or a list in your conference brief. It doesn't need to be on this form, which doesn't really break down the nuts and bolts of why you're asking for the information. So let me just be clear. There's going to be information about their disclosure that they should have provided based on step 2, right? Which we had just discussed earlier, right? There's basic disclosure that needs to be provided after the financial statement. And if you're getting to a case conference and they haven't provided it, you don't want to say, oh yeah, they need to provide it, let's give them another 30 days. You need to say, why didn't you provide that information? That's what the rule is. The point of the case conference is move to the next step, which we haven't gone to. Okay, and so there's that disclosure, which is, and you can make that like its own little box in a sense, which is like, or a heading, disclosure that should have already been provided by the case conference under Rule 13 3.1 and 3.3, which is the income and the property that we just discussed, and then there's another heading, which is further disclosure. So if there's more information that you need, then you can ask it on top of the basic disclosure. And that's what the point of the Form 20 is to ask for the more complicated disclosure. So let's just take a quick look at the Form 20. Again, there's nothing special to it in my mind. So it's you put the party's name here, and this is a request for information, and you're asking to be provided within X number of days. So usually we do 20 days or 30 days. And do you want it as an affidavit, or do you want the response just to be a letter or
Mm.
just the documents? And then here's the list. Here's the information I'm looking for. One, right?
Mhm.
So if you're putting here 2022 income tax return,
Mhm.
you have lost the plot because that should have been provided already,
Mhm.
right? You shouldn't have to ask for that. That's the problem that we face in family law, is that we're chasing for stuff that there's an
Yeah.
onus to provide, as
Yeah.
opposed to information above the tax return. Let me give you an example of something that's above the tax return.
Okay.
Let's say, for example, somebody is self-employed and they are deducting from their income meals and entertainment.
Mhm.
Okay. And you very much want to know what is included in that line item called meals and entertainment. That is something that you can ask
Mm.
or you should be asking in the request for information. Okay. So um, I would say even I would say the laws even should be a bit more requiring that on the party, that if they are deducting, they should explain their deductions. But what I'm saying is that above and beyond what the basic law has just provided under steps number 1 and 2, that's where this Form 20 request should come. And so you need to be a little bit strategic about what you're asking for so that you're not chasing what should be, like, they should be compelled to be providing what they've already should have provided, as opposed to you chasing for it. Okay.
Mm.
And when you're making your disclosure request, you need to ask, why am I asking for this information? What am I going to do with this information? Sometimes people make wildly long, complicated requests and they get their answers, they get the responses, and they're like, what do I do with it? And
Mm.
the other side says, well, you asked, I answered,
Mhm.
I'm moving along, right?
Mm.
So a Form 20 requires a little bit of forethought as to why you're asking what you're asking for, what's the relevance. Okay. At the case conference, down here, I'm putting stuff that needs to be updated. If your financial statement is 60 days old, you should also update it at the case conference. Okay, now
Mm.
it doesn't need to be a fresh financial statement. You don't have to redo the whole financial statement. You could just do an affidavit that says, you know, my accounts have changed, or I received a bonus on this day, something different that's not on the financial statement. So you can do that, either a fresh, update your financial statement itself, or you could do an updating affidavit to it. But if it's 60 days old, technically that is what's supposed to happen for the case conference for updating. Okay, and so that's the case conference. And before we get to the next step, there is a middle that is not part of the 6 steps that many people will get caught. So right here, right at this moment, you have provided your 13A, which lists your basic disclosure.
Mhm.
You've made a request from the other party for their advanced disclosure, and they will have likely made a further disclosure request of you as well.
Mhm.
And it is at this moment in time that people get caught up in the morass of financial disclosure, because some of these requests may or may not be reasonable.
Mm.
And in the best of scenarios, you would want to review these lists of requests at the case conference. Unfortunately, many people don't come prepared, and they agree that within 7 days or whatever, 10 days, they'll provide their Form 20 requests, which will then be answered. And let me tell you, within those 10 days, people come up with their laundry list of requests that may or may not be reasonable. And people will start to A, get resentment, but B, start to argue over whether or not the disclosure has been responded to or not, and make that its own issue in the litigation. This is so common
Mm.
that it's one of the reasons I started Disclosure Clinic, is like, we need to address this issue of proportionality,
Right.
of these requests, and relevance. Like, why are we asking for all of this information? Like, is it a strategic maneuver to overwhelm someone on the one hand, or is it necessary in order to move forward with a case, in order to resolve the issues that are in front of the court? So one of the tools that a court has that comes to us through civil litigation is called questioning. Out of court questioning. We're not going to talk so much about it. I just want to bring it up that it's not supposed to be common that you do this type of questioning. Many lawyers or parties will just agree to it, not realizing what they're agreeing to, but there is an expense to prepare for it, to attend it, and also to order the transcripts of these out of court examinations. And basically what's supposed to happen from these out of court questions is there's going to be further information that's sought. There are admissions that are going to be sought. Admission means that you admit that something that is not really in your favor is true. And then there's undertakings, which is where you undertake to provide further documentation. So that's questioning, and many people get very stuck in this scenario between the case conference and the settlement conference. And you want to avoid that game. You want to focus, why am I in this court case at all? How do I get out of it, right? And it may require going back to a court in order to narrow the disclosure that was asked for. In other words, to say that perhaps the disclosure that was asked for is not reasonable or is not proportionate. Okay.